I think we'll get started. Good afternoon, everyone, and a very warm welcome to all of you in this inaugural edition of GlobalLinker Growth Talks, where we'll be talking about India's labor law reforms and its impact to the SME segment. My name is Satyendra Agarwal, representing GlobalLinker, and I'm joining you all from Singapore. A very quick introduction to GlobalLinker and who we are. So we are an online ecosystem to connect and empower SMEs. We basically enable the digital presence, of SMEs. We connect them with each other, so SMEs can find new buyers, suppliers, or opportunities on the platform. We help SMEs learn and grow, and we hope the session today is again one of our initiatives, around those lines. We help SMEs build their digital presence by helping you digitize your product catalogs, helping you with, if you're in B2B, to help you list your products, on our B2B platform. Equally, we help you, create your own online stores. And lastly, we bring in, the required solutions through our partners onto the platform, often at a pre-negotiated or at an exclusive price. Today, we have over 350,000 SMEs on the platform who've made over 1.2 million connections and are enjoying the benefit, of being a part of a single large community. When it comes to growth never takes, or happens on its own or by chance. It's often a result of various forces coming together. To support the growth of SMEs, GlobalLinker Growth Talks brings together industry experts and domain specialists to share practical knowledge and tips, in a series of growth-focused webinars. In this inaugural edition of GlobalLinker Growth Talks, we're excited to partner with Wadhwani Foundation and experts from Khaitan Legal Associates to talk about India's labor law reforms. First up, I would like to invite Sameer Sathe from Wadhwani Foundation, who heads the Wadhwani Advantage program. So we do have a broader partnership with Wadhwani Foundation, where we're committed to help with the growth of secondly with the tools and capabilities, which Wadhwani brings for SMEs. And I'm sure Sameer would kind of touch upon that, in the course of next 60 minutes or so. So welcome, Sameer, and over to you.
Thank you, Satyam. Thank you. Thank you, GlobalLinker, for inviting us over here. And this is a very exciting start to this series of the most important topic that is there in the minds of all of us, which is growth. And growth is life, as we all know. I think in this first session, we have picked up a very interesting topic, very relevant topic, which is the labor reforms. And particularly, we are interested in looking at the impact of what's happening in these areas on the small businesses, which is really the backbone of Indian economy, and not only Indian economy, for that matter, across the world. Because as we all know, small businesses are the largest source of employment in most of the economies globally. And at the same time, in India, it is indeed a backbone because they are today controlling close to a third of our Indian GDP. And of course, our ministry has set a target to have their contribution close to 40% of the GDP in years to come. Given the COVID context that we had in 2020, the world that is ahead of SMEs is today full of lots of options, lots of scenarios, in many cases uncertain. And the anxiety that it throws on the minds of the entrepreneurs in terms of how they should chart out their growth is really top of the agenda. And in that context, the labor reforms assume a very incredibly important topic, because they are really at the lowest level of granularity on the shop floor, really the builders of growth, because it's through them that the goods and services will be sort of manufactured, produced, delivered, shipped, and consumed across all the sectors in India. Very quickly, what I'll do is in this session, my role is twofold. One is really to talk about very quickly Advantage program, which I will do at the end of the session. I'll let you know in terms of what is it that we do as Advantage program and foundation to be able to help the SMEs accelerate their growth. And the second role that I'm playing, which is going to begin very shortly now, is really to welcome our speakers today from Khaitan Legal Satyendra and Varsha. So welcome both of you. Thank you for being here. Um, and they really are the part of the curated advisory network that we have as Advantage Program and Wadhwani Foundation, and we have deep association with GlobalLinker in terms of looking at connecting SMEs, ensuring that they have the same growth objective as we do, and we have deep association with Khaitan Legal because, as you know, I mean, there is no option for anything which is legal, right? As we all know, and when it comes to legal opinion, it's incredibly important that we hear it from the experts. So the second role I'm going to play is to basically have a bunch of questions for both Satyendra and Varsha, and we will have this session. But before that, let me very quickly introduce both of them, and I leave it to them to elaborate on what specifically they have done. But very quickly, Satyendra, I think, is based in the London office, Khaitan Legal. Satyendra, correct me if I'm wrong. That's what I read in your bio. And of course, although he's based here, I can see his Mumbai numbers and India numbers there as well. I'm pretty sure that he's deeply involved in what is happening on the shores of India. And this is what is most important for us. And I think he looks at the employment practice and regulatory insurance practice. And he's a veteran in that field for probably 15, 16 years. And that's a very quick sort of snapshot about his background. And I will leave it to Satyendra to talk about a little bit more. And Varsha, of course, is based in Bangalore office. And she looks at insurance and education practices on behalf of Khaitan Legal. And both of them come from deep expertise in terms of sharing their views on Indian labor reforms. And of course, through the series of questions, we'll hear more about what they have to say. So what I will do is that I will probably look at this session being organized in two components. The first is where Satyendra and Varsha will sort of narrate and talk about what they feel in a nutshell. I will have some questions for them when they sort of finish their respective sort of narratives in terms of what they want to talk about. We will also have, and that will go on for about 25, 30 minutes. We'll have about 10, 15 minutes for audience to ask questions. Very happy when you sort of put in those questions while we speak and while they speak. In case you have questions, you will see a chat box there and questions section there. That just put those questions out there. Then we will curate those questions and have them asked to this panelist. And then we will follow it up with the last leg of this session, wherein I will talk about Advantage program, which goes much beyond the labor reforms, looks at how the entrepreneurs and all of you, the attendees, the small businesses, how we can help you and chart out your growth. Because at the end of the day, growth is the key agenda, and how labor sort of fits into that growth. So that's really quickly the sort of structure of this session. I'll probably now hand over to Satyendra and Varsha to talk about what they're going to do, what is it that they have on mind when they think about this particular topic. I would request both of you to start with your introductions very quickly. If I missed out on anything, which is very, very particularly important, but let's go ahead. Welcome once again.
Thank you, Samir. Am I audible? Yeah. Okay. Great.
Yes.
Great.
Yeah.
So no, I mean, no one has to check that. So it's very interesting that you read out my introduction. I have nothing more to add except for the fact that the introduction is not updated, very much like the labor laws. So it gels into the theme for the afternoon. That something which had to be done, and it is finally done. So Varsha and I will do a double act, and like all lawyers, for whom brevity is not the soul of wit, but you've given us half an hour. We had 1 hour in mind, so we will see how we can sum things up in half an hour, so that we have more options, more time for Q&A and interaction and so on. So without further ado, we both will just start. I'll just share the screen. I am digitally challenged, so if I'm not able to share the screen, I will trouble Varsha, but let me try.
And this is for the audience. I think we'll keep it probably more question and answer session, Satyendra, if you will, I mean, if you don't mind, because I think at the end of the day, we would want to have audience participation in terms of asking relevant questions that really bother them on a daily basis. Of course, I have a bunch of questions, but we'll carry it on.
That's perfectly fine. That works, because that is the way I think we would want to move also. So I think that will help also. So because see, the presentation is something that everybody has. So maybe what we could do is that we could straight away jump into the headline issues, the key issues that the key takeaways that all should know, and then we can then start answering questions. Okay, then we'll not waste time, and here we go. It's very important for everyone to understand the context within which we are operating, right? 2020 was a landmark year for a variety of reasons, but also because I've never felt so important as an employment lawyer ever in my 16-year-long career. But that year was significant. Why? Because in the first half, when the pandemic began, the government reacted by invoking a draconian law and making all and sundry pay their employees, regardless of whether they were making profits, not profits, whether they were earning money, whether they were incurring losses, etc. So the government invoked Disaster Management Act and came out with a mandate to pay the employees and not to terminate them. On the other hand, in the latter part of the year, you have the labor law reforms. I mean, something which was pending for God knows how many years, and suddenly you have 3 major labor codes being passed by the parliament, and frankly, as a lawyer, I never thought that I would see that day in this lifetime, that the archaic and old labor laws get reformed. Even when the government started this exercise in 2016, when they set up a committee to look into this, I thought it was like any other program or the initiative of the government to do something which was so politically sensitive. I mean, if you look at it, India embarked on the journey of liberalization in 1991, but labor, because of the sensitivities surrounding labor and agriculture now, as you see, nobody touched it, right? It was a politically sensitive subject to touch. But here you have a government which almost bit the bullet and implemented or rather showed the political resolve to implement what they had promised. So it was an interesting thing. I mean, so in this context, it is very important to understand. It is very important to understand the direction of the course. Where we were and where are we headed. Now, 44 labor laws have been consolidated into 4 codes. So 25-30 minutes may not be sufficient to make you all experts, but we can always get into the key takeaways. Okay. Now, the purpose of codification of labor laws, right? What is the purpose? To transform old and archaic labor laws. When we talk to clients and we say that, okay, the main law that governs industrial relations is Industrial Disputes Act of 1947, even before we attained independence, or right at the time when we were attaining independence, the clients who were especially from outside India, they would smirk and say, oh, you've not changed your laws, and we would sheepishly admit that yeah, these laws have not undergone significant changes. Similarly, simplification of labor laws. So, in India, the construct or the structure of employment laws is very, very interesting. Employment law, they form a part of the concurrent list of the Constitution, which means the center and the state both have the power to legislate. Now, interestingly, even the laws that the central government legislates, the enforcement happens at the level of the state governments. So, the state governments that are more industry friendly will implement the same set of laws in a very different way. And, the state governments which are not so industry friendly, will implement the same set of laws in a different way. So, so it's a very interesting thing, when states compete with each other to attract foreign investment, one of the major, spins or one of the major spiels they look for is, they said, okay, there is industrial peace and harmony in a particular state. So it's very important to understand that the purpose of this entire exercise is also to simplify the laws, right? and lawyers like us sometimes are the indirect beneficiaries when laws are not simple, but that's another story. So ensuring ease of compliance and ability to do business. If you see the theme of the government, okay, since 2014 has been ease of doing business. And in order to ensure ease of doing business, ease of compliance as far as labor laws is concerned is a significant criteria. So while you may have access to capital, you may have access to simpler laws, as far as structuring your investments is concerned, so on and so forth. But if you don't have laws that respond to the emerging realities of your business, then from an employment law perspective, then it is battle half won. Similarly, rationalizing penalties and increasing implementation and ensuring wider coverage and social labor welfare. Now, if you look at employment laws, there are two ends of the spectrum. One is the rights of the employers in terms of what the employers want in terms of flexibility, freedom, freedom to hire, freedom to fire, limited compliance. And on the other side of the spectrum, you have employees. Now, the challenge before the government is finding the middle ground with respect to both these spectrums. So the rights of the employees on one hand, and the rights of the employers on one hand, and in the middle you have things like flexibility, freedom of enterprise, and the welfare, the social welfare of the employees, right? So against this backdrop, the entire mammoth and Herculean exercise of codification and consolidation of all the different laws into these 4 codes began. And here we are right now, waiting for the entire framework to come into play, so that we are able to at least see how these laws are impacting us. So right now, while the laws have been passed by the Parliament, they are not in force as such, because what happens that with these laws, as I said, that these laws will have a rule-based. There is a necessity for a rule-based framework for the implementation of the laws. So those rules will come out not only from the central government, but they will also come out from the state governments. So you have we are still a few months away from how the final structure of the reformed employment and labor law would look like. And therefore, I'm not surprised that the journalists are having a field day in terms of giving this their interpretation. So one fine day, one news report will say that, okay, you have 4 working day. The other day, people will come and say that, okay, work from home will be a statutory right. Okay, so all of this, there are still these finer nuances of the code, which will only be crystallized once the rules that are there, that have been issued by the central government and the rules followed by the state government are finalized. So yeah, so now we'll just quickly quickly look at the 3 main codes, that were passed by the Parliament in September of last year. The 4th code, so like this entire regime has 4 pillars. The first code, or the 4th code, which is the code on wages, that was enacted and enforced in 2019. Okay, so the remainder 3 got passed by the Parliament in the September 2020 session. And interestingly, it's such a transformative exercise, but it took less than a week because there was no debate surrounding it. But as we know, I don't want to sound alarmist about it, because these days the debates on legislations, they don't happen in the Parliament, but they happen in the standing committee. So that is where they get in experts, and there is a wider political consensus on how a particular law would look like. So therefore, most debates, discussions, etc., on legislations, they happen in the standing committee, and this has been going on for a while. You can go to the website and you can even check the respective comments made by different political parties and the different organizations which are stakeholders in this entire exercise. So let's begin. Let's see the timeline. I will not get into the timeline. It's there, and you all have access to the presentation as well. Let's start with the Industrial Relations Code. Now, Industrial Relations Code is it's the if I'm allowed to use the metaphor, I mean it's a Bible of industrial laws in India. Industrial relations would define the relationships between the employer and the employee. Okay, if I have to put it, if I have to sum up. So what does Industrial Code do? The IR Code basically replaces three central laws, in relation to India, industrial relations, which is the Trade Union Act of 1926. And 1926, again, as I said, is not a typographical error. It is even before the Second World War. So you have a Trade Union Act, which is, as old as, 1926. So almost about 100-year-old law. Then you have the Industrial Employment Standing Orders Act, which is 1946, and the Industrial Disputes Act of 1947. So what the IR Code does, it replaces all these three major laws on industrial relations. Okay. Now, what are the key highlights? And this is something that, these are the takeaways. So, it seeks to consolidate and amend the laws relating to trade unions, conditions of employment in industrial establishments, and settlement of industrial disputes. It defines workers' strike, industry, and retrenchment, and we'll come to it, separately. It introduces a very interesting concept of fixed-term employee and reskilling fund, and we will deal with that also in the next slide. The standing orders would apply to industrial establishments with more than 300 employees. Okay, so now see what has happened. Okay, in India, always whenever we, the late Pranab Mukherjee, the president of India, he had a very interesting point to make about India. He said that whatever you say about India, the opposite is equally true. Okay, so when lawyers or consultants scare you out of, scare you about, say, a draconian law like, draconian regime like employment laws, you should also ask this question that whether everything applies to you. And there the answer may be no, everything may not apply to you. So what these codes have done is that they have also tinkered with the eligibility thresholds. Okay, so which means, and that is a good news for SMEs. Varsha and I were having a chat before this, and Varsha said, okay, please cut the crap and tell me in one line, if we have to tell the participants today that whether these codes, whether you would give a thumbs up to these codes or not, as far as the SMEs are concerned. And I said that, look, I would be inclined to say yes, that it is something which is to the benefit of SMEs. And one of the reasons is that it has tinkered with the threshold. So standing orders, which means is another it's a set of codes under the Industrial Employment Standing Order Act, which is applicable typically to establishments with 50 or more employees in different states. And what you're required to do is that you're required to get your handbooks or get your service manuals certified from the labor authorities. Okay, so which means that, okay, how you want to give leave, how you want to initiate a disciplinary hearing, what will be the different classification of employees, all of that need to be recorded in a kind of a manual, and that manual needs to be certified from the labor department. Now, that was, any interaction with the government is a painful exercise in India, as you would know. So, what the code does is that, it makes the application of standing orders only if you have 300 or more employees. So it's a good news for SMEs. Okay, and moving on, they have a concept of negotiating trade union and trade councils, etc. that's been introduced, and we'll discuss that in the next slide. And lastly, it's about the reference to arbitration as far as the employment disputes are concerned. That is not something new, but it is something which has been very elaborately done. Now, what are the definitions? Now, one thing is very important that we have to bear in mind, that who does the law protect? Okay, and this is a recurrent theme across all aspects of employment law, and you should kind of bear that in mind. Under the current regime, it's the workmen. Okay, you would have come across this. It's defined under the Industrial Disputes Act. In the new regime, they have replaced workmen with worker. Okay, so I will not get into the details as to what is a worker because we have paucity of time. But from a general guidance perspective, if you have an employee who is a managerial employee, okay, or he renders administrative and supervisory duties and earns over 18,000, he would not be considered as a worker. Okay. Just a point of just a point to remember that 18,000 is not a singular criteria. It has to be read with supervisory function. Okay, so if you have, say, if you hired a software developer and he does not renders any supervisory functions and also earns like maybe ₹1 lakh a month, he would still be considered as a worker. And why it is important to know whether a person is a worker or not, because if a person would qualify, if an employee would qualify within the definition of worker, then he would get the protection under the Act. If he does not get qualified as a worker, then there is no protection available, which means that you have a manager, you're the owner of the company, you don't like the color of his shirt, you can ask him to not come from the following day. I mean, it's as easy as that. And I'm trying to kind of be flippant about it, but that is the way to kind of distinguish the law for you. Okay. Similarly, they have expanded the definition of industry, or rather, they have restricted the definition of industry. Now, any establishment which is engaged in charitable or social or philanthropic service, that has been excluded. Earlier, any kind of economic activity, whether or not profit was the motive, was also included in the definition of industry. Strikes similarly includes concerted casual leave by 50 or more workers. Okay. Now, important term. Okay. So this is I think one of the most significant new concepts that these codes are toying with. Okay. So they have introduced the concept of fixed term employment. Okay. What is a fixed term employment? Fixed term of employment means.
This really caught my attention, fixed term employment.
Yeah.
And, in the past, we have received like so many advices, and especially from the West, where they want to understand on fixed term employment and, how this is a game changer, in the overall scheme of things. Like,
Right.
do you see this as a significant move by the government to codify fixed term employment?
Yes, Varsha, that's a very important, concept. So see, earlier what used to happen that, you just had two type of employees. Okay, either somebody would be a permanent employee, which is, your regular employee, or you would hire somebody through a contracting agency, right? So somebody who's been hired through a contractor. Now, many times there are certain type of employments which you may not require for perpetuity or for eternity, right? I mean, these days nothing is for eternity. We are living in a Tinder world. So it's like in the fixed term employment, there is this new category that has been statutorily or legally recognized, which says that, okay, if you want to hire somebody, okay, for a fixed period, you could still hire him, and then upon the expiry of the fixed term, the employment relationship would come to an end. So it is not a permanent relationship. It is not something for life, and it would therefore give a lot of flexibility to the employers in terms of designing their workforce. Many times, you are taking up new projects and you want that flexibility, but that flexibility is not given to you because then, your balance sheet is burdened with the cost of that employee, or else you undertake redundancy or make them resign and undergo, other compliances. So fixed term employment is one of the revolutionary concepts. But what employers need to also bear in mind is that while it gives them flexibility and freedom, but it also gives the employees the assurance that even if they are fixed term employees, they will be protected at par with permanent employees as far as their rights are concerned for that particular fixed period. So fixed term employment is a win-win for both, in my view. Okay. Okay. Next is the trade unions. In the SME segment, except when you have manufacturing, generally you're not, you don't have to deal with trade unions so much, but we would still, given that it's a new concept, the concept of negotiating union and negotiating council have been introduced. So you have the concept of a negotiating trade union where there is more than one. So if you have a single trade union in your establishment, then obviously that becomes the negotiating trade union. But if you have more than one trade union, which we see in larger establishments, then there is an entire framework provided as to how there will be a negotiating trade union, which will comprise of more than 15% of membership of the workers on the muster roll. Okay, and then if you have multiple trade unions, then which how you determine a negotiating council, that has also been provided. Okay. The most important part of the employee relationship from a point of view of employer is the right to fire. Okay. Now, frankly, if you look at the pink press and there has been a lot of discussion on how India is going the China way, and there is a lot of naysayers who've written everything under the sun about these new laws. But I would just like to kind of clarify that this law does not do anything like that, right? It is not that it is completely changing the way in which employment would end, or employers would fire people. There are some interesting changes. I mean, as I said, that there is a tinkering of the thresholds. Okay, so for example, if you look at the Industrial Disputes Act, what they do is that the requirement of prior permission, okay, of the government, if you even want to retrench a single worker in an industrial establishment, okay, that has gone up from 100 to 300. So earlier, what used to happen, that if you are a factory, okay, and if you have a factory which has more than 100 workmen, then you had to take the prior approval of the government if you wanted to retrench even a single employee, I mean, single worker. Okay. Now that thing has gone up to 300. So it is going to help, a lot of MSMEs, who don't meet this threshold. So it is indeed a welcome step. Now, with the governments, they give you from one hand and they take something from the other. So in terms of the financial impact of this entire new provisions, so from the point of view of what the worker is entitled to, that has not changed directly. But what the government has done is that they have introduced a new concept which is called the Reskilling Fund. Okay, so apart from the fact that there has been a change in the thresholds, there has been a new concept of Reskilling Fund that has been introduced, whereby the employers will be required to contribute to a reskilling fund that will be instituted by the government, and it will be the amount that needs to be contributed will be 15 days salary for it will be a 15-day salary as per the latest remuneration drawn by the individual, and this amount will be credited eventually to the account of the employee who has been retrenched. Okay, so just so that you are aware, while it may be easier for you to undertake retrenchment is termination of employees and termination of workmen, but there is this additional cost that has been saddled onto you as an employer. Okay, but sometimes as lawyers we would say that anything that makes your job easy is worth the cost. So There. The next bit is on grievance redressal, and this is something which is self-explanatory. So, the entire quasi-judicial framework with respect to grievance like labor courts, etc., have been done away with. So now you will only have industrial tribunals, and then you have courts. Similarly, there is a provision to refer to disputes, refer disputes to arbitration through mutual consent. Okay. There are penalties now. Interestingly, there is a new concept, which has been introduced with respect to penalties, and that is compounding of offences. And I would just request Varsha to, kind of just highlight as to what is compounding of offences, because this is a concept that is coming in from, the non-labor world. It's coming from the corporate laws. Varsha.
Thanks, Satyendra.
Varsha, sorry, this is Samir. Before you begin, just a quick check. Satyendra, while Varsha talks about these details, may I request you to go through the Q&A box, which is decided with lots of questions, which is very good sign. So if you could just browse through those questions, so that when Varsha finishes, maybe you could touch upon some of them.
All right.
Okay. Thank you.
Thanks, Samir. So, Satyendra, this is very interesting to see that such concepts are now coming in labor-related code, because we have often seen this to be a big problem among corporates. And I'll tell you what is the difference, when a procedure like compounding is implemented, when it's not. Say, suppose an organization has defaulted on certain compliances, and they know they have not done it. So typically the process would be that they would be sitting silent on it till an investigation is carried out, and it's unearthed and they receive a show cause notice, and then the whole procedure for penalty takes place. But when there is a compounding procedure, then organization can go to the authorities on their own, saying that there has been a non-compliance and they want to now make it compliant. So they make an application, they work with the authorities on it, so they pay a penalty, and the non-compliance is then rectified. From a startup and SME perspective, this is a welcome move, because, like I would say, founders will not have sleepless nights now, because they know there has been non-compliance and they can't do anything about it. So in diligence also they can come out clean, because they can resort to such compounding process. Okay. Now, the only thing is, like we said, devil lies in the details. So we'll still have to see when it's actually implemented, what's the time that authorities are taking to, in fact, to complete the compounding procedure.
Yeah. No, thank you, Varsha. So there are very interesting questions. Shall I take a few of them right away?
Yeah, perhaps you could, Satyendra, because I'm assuming that you will move on to the other topic. So if it helps you to answer the questions while the topic is being discussed, you're welcome to do that, or you could take them up later also. I'll leave it to you.
Yeah, we'll just, just to kind of, given that I've opened it, so I might as well. So the first is that, is this code now a law? Now this is the most commonly asked questions. And so the short answer to that is no, not now, but it will be shortly. From what we hear, the murmurs in the corridors of power is that the government intends to implement this by the 1st of April. Although the rule-based framework, as I said, is currently underway. So it is likely that what they would do is that they would bring some parts of the codes into effect. That's how they have done with several laws in the past also. That there are certain provisions of the law that they would bring into effect, which are low-hanging fruits in terms of the ability of the government to enforce. But there are certain things which would require, say, the rules coming up from the state governments, or other rules being notified by the central government. Then they may take some more time in terms of the implementation. So our take is that you should prepare for these laws as if they are going to be implemented from 1st April, but wait for the final notifications. Okay. The other question is, can we split the minimum wages for contacting the PF in the new code? I'm not able to understand this, but the what I understand is that when you say split, which means structuring of wages for the creativity that most HR people and accounting people used to display while structuring of remuneration may be done away with, because the definition of wages in the wage code is very clear, that there are certain allowances which will not form a part of the basic wage, and there will be certain allowances which will be considered as allowances. So, and if you are not if at any point in time the total if total wages, if the total basket of allowances exceed 50% of the basic wage, then such excess will be considered as basic wage. So at every point in time, 50% of your total remuneration will have to be considered as being outside the bracket of allowances, which means that it will be considered as basic, and the contributions will be determined accordingly. Okay. Now, in a particular site, if there are workers less than 100, in the employer can lay off or do a closure of the factory without informing the government. Yes, when the law comes into force, you will be able to do that. It'll only be for layoff and retrenchment. It will not be for closure, because for closure you would still need to notify the government. Okay. There again, when the new codes come into effect, which I have answered. This is a question from Mr. Sachin Kadam. He says that he agrees with the win-win situation in fixed term employment, but what if the worker is not performing at his best or as per company requirement? What action can an employer or HR can take? Now, remember that fixed term employment does not mean that your hands are tied down in terms of not taking any action against the employer for underperformance or otherwise. Okay, so the employee would still be subject to the regular codes of conduct, regular disciplinary initiatives or disciplinary codes of the employer. There is nothing that gives him additional right. Okay, it is just that the rights for so long as he is employed are protected under the fixed term employment. So you can still dismiss or retrench the employee by paying him whatever is the term. Now, Mr. Rathi is asking that 11-month employment contracts are regular in industry, how this would be considered for fixed term contract benefit. You're right, sir. This is regular in the industry, and lawyers like us are to be blamed for that. For a variety of reasons, we often allow our clients to issue something like this, a fixed term contracts. But so from an employee's perspective, this will be beneficial, because it's the gray area with respect to whether it's an employment term or not that the employer has been taking had been taking advantage of will no longer be the position. So if the employee is on a fixed term employment and he's completed, say, 1 year, he would, and if he leaves, he would still be entitled to gratuity on a pro rata basis. Okay. Okay. Now I will move on to the next part, because we are already a little behind time. Okay.
So before you move to the next one, Satyendra, just a quick sort of guidance to all the audience. I think all your questions will be tabulated and will be recorded at our end, so that you will have a chance to get the answers from the experts a little later, if all of them are not covered in this session, because I assume that you will have lots of questions. I can clearly see that you are deeply interested in asking a lot of questions, which is a good sign.
Yeah.
But due to the session timings, we may not be able to cover all that. But be assured that those questions will be answered eventually, and we'll take a call on it will reach you in due course of time.
Yeah.
Sorry, move ahead.
Yeah, Samir, I also just want to make a little bit of a disclaimer there, that there are certain questions which are very specific, right? So in order to address certain questions which are extremely specific, we will need to get more information. It'll be it'll not be productive. It'll be counterproductive rather if we give them answers without having all the necessary background information.
Absolutely, that's appreciated. And this is for the audience. I think you will know the lawyer to answer exactly and correctly. They will need the right inputs. So we must understand that there are some questions which are definitely answerable right now or later. Some questions you will need to seek a professional opinion from them later. So I think we'll take a call on which answers they will give and which answers would need a more inputs from you a little later. Thank you.
Yeah. All right. Okay. The next one is the Code on Occupational Safety, Health, and Working Conditions. Okay. Now this is the one which it kind of consolidates around 13 to 14 laws together, and mainly this would cover the manufacturing sector, which is the Factories Act. Okay, and we don't have the time to get it in the details for the entire thing, but we'll just look at the main. So the applicability. Now, the applicability of the OSH code, for sake of simplicity, we can call it the OSH code, is for any industry, trade, or business where with 10 or more workers, and it also applies to factories with 10 or more workers. In case of contract, in case of establishments that employ contract labor, it will be for more than 50 contract workers. Okay. Now, there are these thresholds, and you will have the presentations with you. So I'm not getting into the details of the welfare measures of safety officers and welfare provisions and welfare officers and so on. Now, key highlights. So employers are required to conduct free annual health checkups for their employees. Now, this is a very interesting measure. So it's a welfare measure, and again, the employers cannot saddle this cost on the employees. Okay, so this is something this is going to have a financial implication, and typically employees do provide employee benefits in forms of insurance. So maybe you could get this. You could pass this cost on to the insurers, who will be more than willing to help you. And please don't say that your lawyers suggested this. But so the second is the occupier. Now for I don't know how many of you deal with hazardous processes and manufacturing of hazardous substances. But if you remember the Bhopal gas tragedy and the law that required changing after that, was that they tried to fix the liability at the highest levels of management, with respect to factories. And what had that then led to a situation that the entire board, whether it's an executive director or an independent director who is not rendering any executive function, they used to be embroiled in unnecessary litigation. So the law here has clarified as to what is the definition of occupier from a factory perspective, and it clearly sets out that it excludes independent directors. So it's a welcome relief. Issuance of appointment letter to every employee on their appointment in the establishment. Now, this is a very interesting one. As lawyers, and I would ask Varsha to chip in here. But as lawyers, we face this all the time. Many times, these all the establishments would ask us that, okay, is it mandatory to provide an employment contract? And we would say, no, it varies from state to state. So for the first time, a central law, which has an applicability across India, is issuing this diktat or is issuing the mandate that an appointment letter or an employment contract, by whatever name you would want to call it, must be given to every employee. Varsha, your take?
Satyen, a very good move by the government. First is because it brings in uniformity. And like you said, the interesting bit is that it's coming in the Central Act and not from state-specific rules. Second is, from a SME and startup perspective, this really helps them, because what we have often seen in the past is that, these are the kind of, smaller things that gets left out, with founders being, extremely busy with their business. So this also brings in, a sense of clarity that they know this needs to be done, as opposed to, just being in that fix, whether they should do it or not.
Right.
And from an employee perspective, this brings them clarity as to what their terms of employment are.
Yeah. Thanks, Varsha. So the next one is this concept of core activity of an establishment. Okay, so earlier the contract labor law, it said that if an employee has been, if a contract worker has been employed in any activity which as per the understanding or the assessment of the state government is not an activity where you can hire contract labor, you will not be allowed to hire contract labor in those activities. So then you can only hire permanent employees. Okay, so which means that the government in a particular state can decide as to what you consider as a core activity or as a perennial activity, as they call it, or not. Okay, now this used to hinder the flexibility and freedom of the employers in hiring their workforce. So that has been not completely done away with, but the government is open to the idea of firstly, they have made it very clear as to what is non-core. So like, your gardening, sanitation, canteen, all other services, they have clearly defined as to that is not a non-core activity, and there you can clearly hire contract labor. Okay, so it is completely settled and done. In addition to that, what the OSH code is saying is that even for a core activity, you may be permitted to hire a contract labor. Okay, so this is this is something which is fundamentally different from what was the position of law in the earlier regime. So as if you read this with allowing fixed term contract, okay, and allowing you to hire hire workers, hire contract labor in core activities, plus if you look at the tinkering of the thresholds. So all of this is a welcome sign that okay, government is moving towards laissez-faire. So rather than dictating you as to what you can do with or how you can structure your workforce and so on, they're saying that okay, even if you want to do, please do it, but you will need to take proper approvals, or you will need to notify the authorities if you're doing something like this in the core activity. Okay. Then employers or contractors are responsible to provide for welfare activities for interstate migrants, and we have a slide for interstate migrants later on, so we'll discuss that. But see, the main principle of law does not change. That the principal employer. So like even if as an employer, if you are hiring certain services through a contractor, the primary liability under law will always be yours. You can then maybe recover certain things from your service provider, but you should ensure that the rights of the workers who work for you through the contractor are always respected and met. Provides for prior consent of women for overtime and night shift. Now, the call center revolution or the BPO revolution in India, exposed us to this major regulatory lacuna that women were not allowed to work, beyond 8 p.m. In many establishments in many states. So while several, establishments tweaked their laws, the shops and establishment related laws, there was no uniform law across the country that would address this issue. Now this issue has been addressed. Okay, so subject to the consent of the women could be allowed to work night shifts and subject to the safeguards, and those safeguards will be published when the rules are finalized. Then you have again, it's a establishment of a National Occupational Safety and Health Advisory Board, which will work as a quasi-regulator in this space. Okay, now interstate migrants.
Hi, Satyendra. Yeah. Sorry to interrupt. Just a quick time check. We have 5 minutes left. I'm afraid 5 to 7 minutes.
Yes, so we will just wind this up, and then for Social Security, I'll just take 1 minute, and then
sure.
We'll be through.
Thanks.
Okay, so interstate migrants. All of us have heard the plight of the interstate migrants during the COVID crisis, and government has already addressed that in the OSH code. So the liability has been moved to the employer. So if you are employing somebody who falls within the definition of an interstate migrant, okay, which means that any person who's been recruited from any other state, and if his salary is below 18,000, okay, he or she will be considered as interstate migrant, and you will be required to undertake, additional compliances, something like, say, they'll be eligible to get a journey allowance, and in case of any accident or fatality, the employer will be under the obligation to notify the next of kin of these workers. So it's an interesting move, a welcome move. Okay. This we've already discussed this. Penalties, I'm not getting into the details. Now, code on social security. This code on social security, it basically is a very significant code, as it consolidates several laws dealing with social security benefits. Look at the applicability thresholds. There is no change in the applicability thresholds. So Provident Fund still applies to 20 or more, state insurance still applies to 10 or more, gratuity to 10 or more, and maternity benefits to 10 or more. Key highlights of the Social Security Code. One thing you must remember about Social Security codes is that Social Security codes, the government would always look at a strict enforcement of these laws. Right? India does not, while the government would like to believe that it's a welfare state, but it is not a welfare state, and therefore most part of the welfare state, the government passes on its obligation to the private sector to employ people, right? So therefore, your Provident Fund contributions, ESIC contributions, maternity benefits, all of that is very significant, and the courts look at strict enforcement, and there should be no kind of leeway. There should be no. You have no option but absolute compliance. So what does the code do? It extends the benefit of Social Security to workers engaged in unorganized sector, which includes workers operating outside traditional employer-employee relationship and interstate migrants. So if you look at the speech of the Honorable Finance Minister a couple of weeks back, she's also been mentioning about how the government wants to do a lot more for the gig economy, for the platform workers, for the household workers, and so on. So all of these disenfranchised or the marginalized lot have been addressed to in the Social Security Code. We will come to know when the codes come in as to how this, whether the responsibility for the gig economy has also been passed on to the employer or not, but that all will remain to be seen. Changes in the definition of wages. Now, as I said, that this is not something which is a part of the Social Security Code, but it is a part of the wages code. But now there is a proviso which provides that if the excluded components of wages exceed 50% of all remuneration paid, then the amount in excess of 50% will be deemed to be wages. Okay. Provision for voluntary opting in and opting out of EPF and ESIC framework. This is something which is new, and there would hardly be somebody who would want to do this, but that is an option that has been provided. Similarly, establishments can avail common creche facilities by a third party or may pool resources for setting up a common creche. This was a very important clarification that has come up in the Maternity Benefit Act. After the amendment in the law, when the government made it mandatory to have creche facilities for 50 or more employees, for many companies it was a big cost burden, but now the government has said that subject to the rules surrounding it, more than one employer could get together and set up these creche facilities. So it's not necessary that each employer will have an individual creche facility. Limitation period for 5 years being introduced for initiation of inquiries in EPF and ESIC contributions. Now this is a very significant step. There have been several complaints that often apart from the taxman, the other person that the employers often are afraid of in India is the Provident Fund authorities, right? So it's a welcome step where there has been a limitation period provided so that officers don't engage in a fishing expedition and come in, and the employers are not subject to undue harassment. Similarly, filing of electronic returns and introduction. Now, again, gig workers, platform workers, and unorganized workers. So this is something that, we all know that government is moving towards it. The social security benefits will be available to them. In what form and manner, that remains to be seen. Okay. So again, penalties is also self-explanatory. Conclusion, it's a first step, but it is just the beginning. So we can address the questions, and I'm sorry I had to rush to the remaining part, but we'll try to make up in the questions.
Great. So thanks, Satyendra. I really appreciate. Thank you, Varsha. Really appreciate your expert opinions and briefings, as the lawyers would say, probably. Correct me if I'm wrong, on various topics. And that was really helpful. And as you can notice, there are lots of questions that SMEs are asking. And as I mentioned earlier, due to paucity of time, we'll not be able to answer all these questions right now. And then later on, Satyen and Varsha can take a call as to which questions they want to answer upfront. And then they will get back to us on the same, right? So thanks once again for being here. I really appreciate that, Satyen and Satyen and Varsha, thank you. Let's move on to the next leg, next module of this session. As I mentioned at the start, we basically talked about the labor reforms through the expert opinion on from Satyendra and Varsha. And the next topic for today's session was really about Bhadwani Advantage program. As Satyam initially mentioned, this is a part of the growth series, and this is a session that talks about growth. And when we think about growth, Advani Advantage is the program that we want to talk about a little at this stage. We will also talk about how is it that we can help you, all the small business owners, in charting your growth 2x to 3x to 5x to 10x in next few years. Very quickly, an introduction. Wadhwani Foundation, as you can see out there, our focus is helping SMEs build sustainable growth capability internally. That's very important. I think our objective here, move on to the next slides. Our objective here is really to actually talk to entrepreneurs, the owners, the founders, the top management, and ensure that we help them solve their growth problems, right? As you know, in COVID, basically, when we did the analysis of lots of companies in India, we witnessed on an average about 33% to 57% drop in the revenue, the reduction of about 300 basis points in the ROCE. And as you know, because of the COVID crisis, because of the lack of growth, on one hand, we are faced with close to $400 billion worth of credit gap. And on the other, the SMEs in general are looking at basically the NPAs anywhere ranging from 3% to even 36%. And that's massively high sort of incidence. In this midst of all these things, what is it that Wadhwani Foundation is doing? What is it that we are doing? What is it that the Advantage program is doing? So our focus is basically to take you out of this COVID crisis, really protect you, really make you resilient, and not only solve the short-term issues of the cash flows and the cash runways and the working capital, which all of you are facing on a daily basis, but more importantly, ensure that your growth trajectory is steep. It's not limited to you are being where you are in your competitive position as far as your industry is concerned. What you see on screen out here is a tool that we have developed, which is called Genie. Is basically the tool is designed to help you govern the key performance indicators of your business. And we have studied thousands of businesses, and the team that Wadhwani Advantage team, as far as we are concerned, we have together about 300 human years of experience, including us, as well as our curated network of advisors. And that has allowed us to build this tool which is designed to govern the key performance indicators of your business. And these, for anybody who wants to govern the business and check the health, the parameters of your business, this tool will be significant help. So for example, what you will see out here is that there are across the different parameters of orders, sales, cash flows, profitability, workforce, operations, there are a host of about 25 to 28 key performance indicators. We have studied them. We have looked at these key performance indicators. And what we have done is we have automated the entire logic and intelligence, which goes into helping you to understand how is it that you can improve from point A to point B. So for example, if you have a market share of today 10% and you want to improve your market share to 30%, how do you go about doing it, right? So there is a science behind it. There's a science behind revenue growth. There is a science behind whether you want to talk to current customers more, do you want to acquire a new customer. There is a science behind whether you want to focus on the current products, new products. How would you know, how would you make these choices? How would you know whether you want to migrate from one part of the value chain to another part of the value chain? How do you know whether you want to migrate from B2B to B2C, from B2C to B2B? These are all the hard questions that you are day in and day out dealing with. Our tool will allow you, first of all, to check your health, not only in absolute sense, but also in relative sense. So for example, if you are there as an average player, and there are lots of players who are challengers and the market leaders in your industry, our tool will allow you to look at that benchmark and say, here is where you need to reach. So we have studied the benchmark across the different industries in B2B manufacturing specifically. As we speak, we are looking at the benchmarks in B2C as well. But what this allows you to do is that if your cost of manufacturing, for example, is 55%, and if I come and tell you that in an industry, your average cost, the market leader has, let's say, 47% cost of manufacturing, you already know what you're working towards, right? And this is just one example. Similarly, we have developed that for 28 key performance indicators. We have also focused on 8 most important key performance indicators that you should look at: revenue, order book position, cash runway, working capital, there is a cost of manufacturing, gross margins, etc. And I think what this tool does is that it will allow you to look at on a longitudinal axis. So it's just not about where you are today, where you were 5 quarters ago, where you are going to be next 2 quarters hence, and then looking at the short term and the long term. This automates the advice which is needed, or the root cause analysis or correlating factors which are responsible for your health parameters. Is it just like when you visit a doctor and doctor tells you, let's do a medical test, let's check these parameters. We will basically then find out whether any deeper investigation is required. We will do exactly that. We will come with our parameters. We will do a quick check that will throw certain parameters which are altered. Then we'll tell you that there is a deeper investigation which is required. Then we have designed a tool which allows you to study that particular KPI or the key performance indicator, which will then do a deeper investigation. So it's like doctor telling you, hey, you have a stomachache, I think we need to do a CT scan, for example. So we'll do the CT scan. And CT scan might throw up a certain ailment in the stomach, and then that's the treatment path will be designed based on that. So our role in this entire ecosystem is to basically allow you with this tool to monitor your health parameters, business health parameters, and give you a 360-degree support, which you can see on the right-hand side of the slide. The 360-degree support that will allow you to basically know what is your treatment pathway, how are you going to fix the problems that your businesses are having. Is it a customer issue? Is it a product issue? Is it a competitive position issue? Is it really the market share issue? Is it really the margin issue? Is it really the internal capability issue? Is it really the circumstances? Do you need to really rely on others to make it happen? Do you need to acquire capabilities? Do you need to build capabilities? These are the host of questions. And the 360-degree support is basically giving you the knowledge, the content, the curated network of advisors, which will allow you to not only look at your health parameters and where you are, but we will also give you our proprietary Wadhwani index or score, which will basically compute that where is it that you need to go using these different levers or different techniques or different types of support that we are giving on our technology platform. So that's the Genie product for you at this point of time. Just move ahead, Sagar, in the interest of time. So what we basically do is that we will engage with you, registering you on the platform, and then basically we'll talk to yourself, we'll talk to your direct reports, we'll talk to the functional experts, have conversations, allow you to use your own internal data within the company to show to you how data-based decision makings can be done. Excuse me. So how the database decisions could be made, and that will allow all the entrepreneurs and all your direct reports to learn how to solve your problem. It's not limited to any consultant walking in and solving your problem. Our role is basically to ensure that we empower you to know how to solve a problem. And that means we are going to make you Atmanirbhar and self-sustainable based on how we will train you, not only you as an entrepreneur, owner, founder, promoter, top management, but also your people who are feet on street, who are the functional heads, to be able to understand how to manage growth. So that's what this tool does. Just go ahead, Sagar. I think very quickly to tell you the experience that we have in 2019 and 2020, we have helped almost 700 businesses. And I think the good part about what we do is that as a foundation, we are a philanthropy. So our endeavor is not to come there and make money. Our endeavor is to ensure that we as a philanthropy will offer you pro bono services, but we have curated network of advisors who would typically come and then on a need basis, post we administer a business discovery tool, will come back and give you a much subsidized charge rates and a much or largely on success fee basis. And therefore what happens is that you are able to take world-class advice, mentorship, knowledge, but at the same time, it becomes affordable for you to look at it. And I think from our perspective, the reason that we differentiate from other communities which typically help a lot of these businesses is that today in the marketplace, there are very few bodies, the few entities who focus on helping the small businesses like yours. And I think our whole endeavor is to make the Indian ecosystem robust enough. As you know, in India, we have millions of small entrepreneurs. Some of them would be very small, some of them will be large, some of them will be mid-size. I think what it allows us to do is to basically give you that extensive personalized intervention, its ability to empower you. So it's all learning by doing. We also have a technology play, so therefore it allows you to scale up significantly, and we will give you the entire hand-holding support. That's very important. It's just not about giving you a tool and running away. Our consultants will give you hand-holding support throughout your journey as you scale up from 2x to 3x to 4x to 5x in terms of your revenue. So that's going to be a very, very important area as far as we are concerned. I'll probably skip some of the slides in the interest of time, but the idea is that this tool has undergone significant rigorous tests, right? Go ahead, Sagar. Significant tests in terms of logical derivations of how we want to basically help you. So just to give you a sketch, this is just a snapshot of a KPI master, which is key performance indicator master. And as you can see, there are benchmarks given, there is a future trend and the past trends, and there is an assessment which comes automated based on the logic of years of experience to tell you on that particular parameter whether you're very good or whether you need to be improving on, whether that needs to be monitored or whether you're very poor. And then there is a narrative on the right hand side which will give you a detailed report or assessment. Go ahead. And these are some of the other snapshots when we think about area of further investigation, like I mentioned earlier, right? If there is one which requires where you relatively are very poor, your organization is very poor compared to your market leaders, we will look at the root cause analysis based on analyzing data, giving you feedback in terms of where is it that you need to fix the problem. And this is an example of snapshot of that. Go ahead. And after that, we will give you an integrated plan. Integrated plan is nothing but putting everything together. So for example, in many cases, a lot of times what happens with patients, and this is again, I'm drawing an analogy from medical sciences, that patients undergo a lot of trouble, right? Sometimes you have a headache, sometimes sometimes there is a problem with the stomach. Now, a doctor has to understand and give you a feedback as to which ailment he or she is going to attack first. And there is a rationale behind that, right? So what we will do is exactly the same. If there are 15 areas that need fixing, if you attempt all of them being done simultaneously, it's very guaranteed based on our experience that it's very tough for you to basically reach the optimal level of performance in all 15 of them. So what we will do is that we will assess and prioritize for you based on a certain rationale as to how is it that you're going to solve first these 2 problems, then take up another 3, then take up another 3. And therefore, over a period of 5 to 6 months and 1 year, when we hold you in the entire program management office, you will be able to solve that problem. You will be in a better condition. You will have learned how to solve that problem using our tool. And that's the journey that we'll walk you through. Go ahead, Sagar. I think this is what I referred to. I wouldn't spend too much time on. Basically, this is in terms of how we are going to ensure that these are the unique benefits that we bring to you. Whom do we want to select? So we want to select organizations who are committed to grow, who are ambitious, have a growth mindset. They're willing to share data with us because we will help you mine that data and give you a feedback in terms of analytics as to how it's going to help your own decision making. And then very importantly, willing to professionalize your organization. So these are the kind of organizations we would help and want to support on a regular basis and handhold in terms of their growth agenda, which is pretty much the theme of this series. Go ahead, Sagar. Go ahead. Go ahead. So this is a very quick snapshot about what we have done in the last 2 years. As you can see, we have supported close to 700 SMEs. There is a concept of net promoter score. I'm not sure how many of you follow it or have heard of it, but this basically indicates a satisfaction. Any score which is considered above 50 is an excellent score, which means by and large customers are happy with us. We have solved 70 different types of problems. We have so far created 3,000 jobs, but our endeavor is to help all of you, hundreds and thousands of such entrepreneurs, to be able to scale it up. And that's a very quick snapshot. Go ahead. These are some of the things that clients talk about us. This deck is going to be available, so you can refer to it later. But I think this is what they have to say about us. Go ahead. Go ahead. Very quick word on our founder and our CEO and our team. So Dr. Bhadwani, whom you see on the left-hand side, has been a serial entrepreneur billionaire in the US. He is very large-hearted. It's just not the size of the wallet that is large, is the size of his heart that is also large. He has pledged $1.5 billion for the whole purpose of job creation. He is a share body, and India is a very nerve center. So his heart is in helping the small businesses in India. And what we have done is that we have invested significantly in ourselves in running this program in India to be able to give that back to the society, to the economy, so that we are able to improve the economic profit of all of your organizations. Go ahead. And we have a team of extremely capable people. I think with GlobalLinker on the left, you can see Barsha, who is in the second row on the right-hand side. She has been sort of looking at relationship with GlobalLinker. And we have Sagar on the call today, also one of the people on the right-hand side, who are maintaining the relationship with GlobalLinker and with Khaitan Legal to take this relationship forward. So all our team members have got significant experience in helping a lot of these enterprises in terms of the. Go ahead. And this is a very quick snapshot about our curated partners. As you can see, the host of them. Yeah, and this is a worldwide presence. So that's broadly it. What I would strongly encourage is that if all of you are interested in learning more about us, I would strongly recommend that you visit our website and go to the link. And Sagar, may I request you to put the relevant links in terms of joining our program either in the chat box or that will be helpful for all our audiences to understand how is it that they can reach out to us. So if you're an organization, yes, absolutely. So if you're an organization interested in talking to us and taking the relationship forward, very happy to sort of take it forward with you. And I think the most important thing is once you learn this, once you take a understanding of what we do a little bit more in detail, we'll be able to help not only in solving the specific problem, but also able to teach you, to train you how to keep solving your problem on a regular basis. Sagar, if you can put those links, and maybe I can read out aloud those links as well, it will be helpful for the audience. Perhaps that will be useful for those who are attending. And what I would request all of you to do is to basically, we have a particular selection tools. We have a process whereby we admit certain companies in terms of whom we think are the eligible ones for taking up this program. And as you can see in the chat box, if you open your chat boxes, take a 1 second. I'll be silent. So go through your chat boxes, and Sagar has put the link in terms of what there is a Survey Monkey out there, the survey which you need to take to be able to reach out to us. And once you do that, then we will guide you in terms of the next steps, in terms of how we are going to help you in the entire journey of your growth. And that's going to be very, very important for all of us. So that's broadly it for now. In the interest of time, I did not want to go into too much of detail right now, but very happy to have any questions from you a little later or even now, and we shall basically look at helping you in terms of taking the journey forward. Thank you so much. So with this, I would suppose that, I think the main topic of the agenda for the session is over. And Satyam, in case you have any specific comments, or Satyen or Varsha, if you have any specific comments, please go ahead. From my point of view, I think we can consider this as concluded.
No specific comments, and thanks a lot to all our audience, and I hope you all found the session useful. Over the course of next few, I would say, hours or days, we'll kind of share, the content as well as try and answer, the questions, as much as possible. Thank you all for your time, and once again, hope to see you, in the next GlobalLinker Growth Talks. Thank you. Bye-bye.
Thank you.